The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of September 14, 2025. The podcast that lost its tails evolving up from little snails. This is your host, Shane Killian. Let's polemize the news of the bogus. And the anti-AI people have just been doing victory laps all over the socials about the settlement in Bartz v. Anthropic. The first thing to know is, there is no settlement yet. The judge has to sign off on it, and he has serious misgivings. More on that later. The second is that settlements aren't precedential. They don't have any sort of effect on other cases, although they're often used by bullies to sue other people and companies and force them to settle even absent all the merits. But you'd never know that to hear the neo-Luddite copy bullies who insist that this means that AI is absolutely 100% theft for all time, while at the same time claiming that two separate district court judges ruling that it's fair use means absolutely nothing. Brandon Butler of Recreate posted a good analysis of why this settlement wouldn't mean much even if it does go through. Quote, "The copyright cartel celebrated the deal, and some suggested it was proof that AI training requires a license. That framing obscures a key fact. Anthropic had already won on the question of whether AI training was a fair use." Exactly! And it wasn't even close. It was, in the words of the judge, quintessentially transformative, spectacularly so, the most transformative any of us are likely to see in our lifetimes. And that's his first point, that it has nothing to do with fair use. Quote, "Judge also was clear that AI training is fair use. He found that training AI models is spectacularly transformative, and further determined that acquiring print copies on the used book market and digitizing them for the purposes of AI training is also fair use. That ruling was not impacted by the settlement." Yeah, but it was kind of negated. The cartel is screeching, "But my piracy!" and complaining about the mass downloading. But if the ultimate use is fair, it shouldn't matter how you got it. That's a fairly well-settled issue that's being abrogated here. Quote, "The settlement doesn't set a precedent for anything, but especially not for licensing AI training. This private settlement cannot bind anyone but these two parties, and Judge also ruled that a market to license AI training is not one the Copyright Act entitles authors to exploit." One thing he's missing, though, this is a class action lawsuit, and that's a big issue, because not only do we not know who the class members are, and unusually the onus is on Anthropic to figure that out somehow, but they'd all be different, with different deals with their publishers, different levels of damage and exposure, and so on. But again, more on that later. Quote, "Copyright's exorbitant statutory damages provisions were likely much more important than the merits in driving Anthropic to settle. This creates a potential death sentence even for a leading company like Anthropic. The amounts involved in this settlement are thus not a reflection of the true market value of copyrighted content in the age of AI, but rather a windfall to these plaintiffs extracted in the shadow of draconian statutory penalties." And as I pointed out on my YouTube channel, this is how they bully you into a settlement absent the merits. This is a huge problem with the system. Quote, "Even the data sourcing question at the heart of the settlement remains wide open. Within days of Judge Alsop's ruling excoriating Anthropic for using shadow libraries, another federal court ruled exactly the opposite. In Cadre v. Meta, Judge Chabria reasoned that fair uses are always unauthorized, so the use of unauthorized copies should be permitted when the ultimate purpose is fair. The plaintiffs in the Anthropic case were aware of this opinion and knew they might end up losing on appeal. That's why they settled. If the case was a slam dunk for them, they could have continued to litigate in pursuit of those sky-high statutory damages." And if you followed my coverage, you know that Anthropic had an interlocutory appeal up to the Ninth Circuit that they were in an extremely good position to prevail on. That means that, if anything, this settlement wasn't at all about Anthropic admitting defeat, but the plaintiffs settling for an amount much lower than the standard liability in order to avoid a court ruling invalidating everything. Butler concludes, mistaking this one-off private settlement for a blueprint for AI licensing requires twisting the facts and ignoring the actual rulings in this case. It's understandable that companies and policymakers are hungry for guidance on these important issues, but they should look to the rulings themselves for that guidance, not to private arrangements extracted under threat of heavy penalties. And it's not only the companies who want guidance. Judge Alsop himself does. He sent an order with 4 pages of questions for the preliminary approval hearing on September 25th. I won't go over them all, but they're questions like, author and publisher file a joint claim providing adequate documentation of their beneficial and legal ownership of the right to reproduce copies and stating that they have reached agreement on how to split their award. One of 3 authors of a single work opts out, while the others file claims to participate, as does the publisher. All the claimants, but not the absent author, have reached an agreement as to how to split the award. As a variant, 2 of 3 opt out. 1 later requests re-inclusion. Upon receiving notice of the re-inclusion request, the 3rd wishes to re-include. A claimant is paid only to be sued later by an author or publisher seeking its share of the recovery. What provisions of the notification and claims processes, or otherwise including case law, would bear on whether or not any such collateral actions could be brought, and, if brought, on how they could be decided. Suppose that while the author and publisher have retained beneficial and legal ownership of that right, a movie studio has acquired the exclusive legal right to prepare derivative works. Does this mean that the movie studio is not in the class and therefore has not given up its potential claim against Anthropic, one turning on its contention that Anthropic created derivative works? And so on. Individually, these might be taken to be technical details, but there are 17 of these all total, and taken together, they really show what a mess this class action suit is. In fact, it really shows why many experts feel there shouldn't be any class action copyright lawsuits at all. Class actions really only work when class members are all the same. When they're as diverse as this, with damages at different levels and spread out against multiple parties? Entire lawsuits have hinged on the rights of a single book or song. Doing this for all the class members when we don't even know who they are? The judge is showing serious misgivings about this settlement, and so should you. And once again, understand the motivation, not to mention the willingness to ignore reality, of all of the anti-AI copy bully Luddites who keep using this as a club to beat us over the head with.
Presenting the greatest game this side of Yugoth. You are H.P. Lovecraft's cat, and your name is Nick. Right, we can't say that on a podcast. Well, anyway, that's the point. Your name is a joke to him. So now, you are out for revenge. Using the Necronomicon, you come to the present day to buy a gun to go vanquish him once and for all. But the Necronomicon is devious, and it summoned Lovecraft's monsters as well. Now, in a crumbling world, you must fight for the revenge you seek. Fight monsters, gain allies, buy guns and armor for yourself and your team. Defeat the bosses of each level. Then get your revenge against Lovecraft himself. Play Lovecraft's Cat. The link is at cat.bogosity.tv. Yeah, we're doing cat.bogosity.tv. Not that other one. What, you want me to get kicked off the internet or something?
So you remember the conspiracy theory where the alternate electors the Republican Party had in place in case the 2020 election disputes fell in their favor were accused of election tampering somehow? Yeah, it never made any sense to me. And it didn't make any sense to Michigan District Court Judge Kristen Simmons either, who threw out Michigan's prosecution against them. Simmons, a Democratic appointee of Governor Gretchen Whitmer, threw out the case against all 15 defendants. You can listen to her entire ruling in the link in the show notes, but here are some highlights.
This is not an election interference case. This is a fraud case, and we have to prove intent. And I don't believe that there's evidence sufficient to prove intent. I believe there's insufficient evidence brought on this record to even establish that the defendants were trained or explained to them what their duties would be and the difference between a duly elected elector versus an elected or nominated elector. But if there's no real distinction and Mr. Renner was doing his civic duty, then that means that they were all doing their civic duty.
And keep in mind, they were each facing 14 years in prison. The average murderer gets 12.
This alternate document doesn't state it's an official document of the state of Michigan, doesn't contain a certificate of vote. No one attempted to forge the governor's signature. No one attempted to create a fake seal. There were also some social media posts that the court can interpret the intent from. I think it was Ms. Lundgren's social media post indicating that they were in Lansing fulfilling their constitutional right, which doesn't demonstrate an intent to defraud. It's an intent to exercise what you believe is your constitutional right. They said they were executing their constitutional right to allow the senators of the state of Michigan to receive an alternate slate, and then the senators could take further action. First of all, I don't know anybody doing a press conference after they're committing a fraud, but to the extent that that's what we're going to do. Their statements make it very clear that they believe that they can seek redress from their state senators, which I believe is a constitutional right.
Ooh, actually understanding the Constitution? The Democrats aren't going to like that!
They knew that the Democratic electors were there. They weren't trying to sneak and get something that looks like it's the real one and replace the other one. That would be an attempt to defraud. And so in this courtroom, we don't really care your race, color, creed, national origins, religious belief, or your political beliefs, but we do care about the law and that we believe that it should be applied to protect every individual equally. And I believe that they were executing their constitutional right to seek redress, and that's based on the statements of all of the people's witnesses. And so for those reasons, these cases will not be bound over to the circuit court. Each case will be dismissed.
So there. One of the defendants, Meshawn Maddox, said, quote, "Yes, we volunteered to be an alternate elector in support of Donald J. Trump. That is not a crime as much as Nessel wanted it to be one. Their goal is not a conviction. It is pure legal harassment. Nessel's defeat today was epic." She's talking about Michigan Attorney General Dana Nessel, who bleated, "If they can get away with this, well, what can't they get away with next? Yes, how dare they get away with exercising their constitutional rights?" Quote, "I am terrified for the 2026 elections, and not because I'm worried somebody I support will lose. I'm worried that President Trump and his aiders and abettors and followers have already ensured that no future American election will ever really be fair or free." Geez, if she won't even listen to a judge appointed by her side, who will she listen to? Cue, of course, the screeching of the left. Ashia Brown, Michigan State Director of All Voting is Local, a leftist group that tries to get out the vote of people only in heavily Democratic areas, said in a statement, "Today's ruling, which dismissed the charges, is yet another blow to the guardrails of our democracy. The 2020 plot to overturn the presidential election results and the subsequent insurrection at the Capitol were just the first glimpses of the lengths President Trump and his political allies will go to undermine American democracy and the will of the people for their own gain. Without consequences for breaking federal law, we only guarantee that these attacks will continue and the safeguards of our elections will continue to be eroded. To dismiss these charges ahead of the 2026 election, which we know are at risk of election sabotage, is disgraceful, as it serves as a green light to those who may again attempt to take the will of the people away. Unfortunately for them, however, we now know their blueprint, and will be watching and ready to fight back against any future attempts at election sabotage." Okay then, moron, why don't you tell us what you're supposed to do in a contested election in the event that you win legally? Oh, I guess we won, but we don't have any electors 'cause it's illegal. Idiot. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. So going back to what I was saying earlier about using court rulings that are so devastating you're really bullying the companies into settling, one that didn't play ball was Cox Communications. We've been covering this case as it's been happening. To recap, there's a $1 billion piracy judgment against them because the RIAA is blaming them for piracy committed by their users, even though they're a common carrier and by all rights should have conduit protections. That was 5 years ago, and after being upheld by the Fourth Circuit, now the case is going up to the Supreme Court. Losing this case would mean nothing less than the loss of what little of our privacy rights are left with communications. And the amicus briefs are coming in supporting Cox, one of which is from the Office of the Solicitor General. They filed, Cox's knowledge that particular accounts will be used to infringe does not support an inference of culpable intent. At worst, Cox was indifferent to infringement, supplying internet access to all customers on equal terms. Sony and the Court of Appeals have identified no evidence that Cox intended for infringement to occur or wished to bring it about. And an ordinary merchant's awareness of a customer's unlawful plans, standing alone, does not demonstrate the desire that those plans succeed. An internet service provider is not liable for contributory copyright infringement for failing to terminate specific subscriber accounts that it is substantially certain will be used to commit direct infringement. The Court of Appeals' sweeping view of contributory copyright infringement could carry serious adverse consequences. Under the decision below, so long as an ISP knows that a specific account is substantially certain to infringe, the ISP is liable for all direct infringement committed on that account. That approach would give ISPs a powerful incentive to err on the side of termination after receiving a notice of infringement for a particular account. Losing internet access is a serious consequence. The internet is the modern public square. Terminations of service would adversely affect not only actual infringers, but also the potentially numerous non-infringing users of terminated accounts. A joint brief was also received from Google, Amazon, Microsoft, Mozilla, and Pinterest. Quote, the court's decision in this case will have a significant impact on a broad range of internet companies that make it possible for Americans to find, create, and share information online. Instead of suing the individuals and businesses alleged to engage in direct infringement, copyright holders frequently target intermediaries with pockets deeper than those of direct infringers. The Fourth Circuit's overbroad standard for contributory infringement liability, if permitted to stand, will open the door to illegitimate lawsuits, like the claim here, that are based solely on providers' failure to act. The Fourth Circuit's holding turns Congress's directive on its head by transforming the safe harbors into a liability-creating mechanism. The lower court determined that the failure to act that made petitioners ineligible for safe harbor, non-termination of service for subscribers alleged in notices from respondents to be repeat infringers, was sufficient to establish contributory infringement. Gee, if only someone had warned people about that 27 years ago! Yes, your humble host himself was pointing out that this so-called safe harbor, which should have been unnecessary given the precedent of conduit protections, instead of granting anything to internet companies, actually took it away. They're now assumed to be liable everywhere the safe harbor doesn't apply, and it only applies if they take active steps. This was not unforeseeable. There are also other filings from a diverse array of ISPs like Altus, AT&T, and Verizon, platforms like X Corp, digital rights groups like the EFF, the American Library Association, and Recreate, and legal scholars at the Copia Institute, the ACLU, and others. And remember that the proof of knowledge of infringement was nothing more than the say-so of a big content cartel that sent an email to the ISP. And again, this is just about taking away the free speech rights of you and me. As X Corp filed, declining to take away an important tool of expression from these ordinary Americans is not the kind of inaction that the doctrine of contributory or aiding and abetting liability was meant to reach. Indeed, this court expressly excluded the providers of these free speech tools from liability. Although copyright owners may assert their claims against individual infringers for direct infringement, they do not generally do so. Instead, as in this case, content owners assemble thousands of copyrighted works allegedly infringed by someone else and sue service providers on theories of secondary liability in pursuit of massive verdicts like the $1 billion awarded by the jury here. Companies offering innovative technology to the internet-using public have no choice but to constrain their actions in the face of that uncertainty and existential risk. There is no evidence Cox derived a penny from its subscribers' conduct. To allow a $1 billion award against a party that did not itself directly infringe, did not participate in the infringement, and did not financially benefit from infringing uses versus non-infringing uses by its subscribers is a grotesque distortion of the purposes of copyright law and common law principles of liability. If you've ever wondered why I spent so much time covering this case, and why I keep saying it's so important for regular people like you and me, if these quotes didn't do it, then read the entire amicus briefs. They're all linked at the bottom of the article in the show notes. If we don't have these rights, we don't have any rights. And now it's time to re-spiritualize this week's biggest Bogon emitter. Is there just no hope for CNN? I mean, when you see a criminally insane person murder an innocent woman who did nothing to him on a train in full view of a dozen people, is it really so bad to ask the question, why wasn't he locked away before this could happen? Apparently it is, according to a panel on CNN's Newsnight, where apparently the only sane panelist, Caroline Downey, had the audacity to say that.
Or North Carolina, not on the verge of violence, actually demonstrated violence in the past and nobody flagged it. Actually, the police, to your point, said, we're going to refer you to more resources, and that went nowhere.
Yeah, that didn't go down well.
He did actually serve time for the violent offenses that he committed.
But he was a career criminal, a repeat offender who was let back onto our streets despite a really bad criminal record that suggests he should have been locked away for life because he was threatening the public. He was a menace to society.
You want him to...
You actually said that. I can't believe you actually said that. Somebody should be locked away in jail forever for schizophrenia. Did you really say that?
Isolated.
Did you really say that?
In an institution.
So we're just pretending to be obtuse, I guess. If you can't actually respond to what she said, just go, did you really say that? In a high-pitched, incredulous voice.
So what you're saying is that this man should have been roaming the streets.
I'm saying
is
that
that
you don't lock people in prison for schizophrenia.
An institution.
What kind of institution?
Man, do I really have to explain this? When someone is insane to the point where they have demonstrated that they cannot be a moral actor, where they have demonstrated that the normal deontological protections of moral actors do not apply to them, where they have demonstrated that they are a danger to others, it's perfectly okay to defend the individuals all around us by incarcerating them in a place where they can get treatment and where people can be protected for as long as that mental deficiency lasts. This is not a new thing, and until today, I didn't even think it was a controversial thing.
I understand that, but at some point, people do get out when they have been treated and rehabilitated.
Sure, but that didn't happen here. He didn't go to an institution at all.
But you're
and
advocating.
So he stabbed a woman and said he should be locked away for life.
Children, we can't understand you if you all talk at the same time.
There's thousands and thousands of people in America, more than, tens, hundreds of thousands, who have been diagnosed with schizophrenia that are walking around and that are leading fairly normal lives because they are under treatment.
Huh. So if that's the case, then I guess you're admitting that your precious red flag laws are completely invalid, Navarro? The ones you personally championed many, many times? Or do things suddenly change when we're talking about your tyranny?
A lot of people
are we going to lock up everybody with schizophrenia for life?
He demonstrated violent proclivities repeatedly.
You said he should be locked away for life for schizophrenia.
So if someone doesn't like what you said, they just make up something else they wish you said and just ignore what you're saying clearly and repeatedly. If it helps, Downey, I know exactly how you feel.
And if you're saying he should not, you're saying that young women like you and me are basically just, we are lambs into the slaughter. You go on public transportation in this city, that could happen to any single one of us.
I use public transit constantly. That is completely unhinged, frankly. People shouldn't be locked away for mental illness. They should be treated for it.
In an institution. Yes.
Just to remind everyone, DeCarlos Brown Jr. committed 14 prior offenses, including robbery with a dangerous weapon and even assault of his own sister. His own family made several attempts to get him treatment. His own mother attempted to get him into a long-term mental care facility, and that failed because she wasn't his legal guardian. And what's going to happen now? He is going to be locked away for life, if not given the death penalty. And an innocent woman is dead on top of it. So what do you people think all your virtue signaling has achieved? So all of that makes CNN this week's biggest Bogon emitter. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. Wow, it took until September, but we now have our second Silver Cluon Award winner for 2025. It seems like the Silver Cluons come less and less often, and this year, weirder and weirder. Our first one was to Mark Zuckerberg, and this one is to a company owned by Google's parent. We're talking about Waymo, the self-driving ride service company owned by Alphabet Inc., which offers driverless rides in San Francisco, LA, Phoenix, Austin, and Atlanta, with more announced over the coming year. And they just stood up for you. In an era where tech companies treat your data like just another commodity and your Alexa or Ring doorbell will narc on you in a hot second, Waymo has announced that they will reject all requests from law enforcement for data from its autonomous vehicles that aren't backed by a warrant or court order. A Waymo spokesperson said, quote, "As a general matter, we require valid legal process, as in the form of a warrant or court order, from law enforcement agencies who seek information and data from Waymo. Our policy is to challenge, limit, or reject requests that do not have a valid legal basis or are overbroad." Waymo co-CEO Takedra Mawakana backed that up, saying, quote, "At the end of the day, We need communities to be able to trust us. The company also informs the public when law enforcement requests data. This trust is important, since each vehicle has 29 external cameras in addition to LiDAR and other sensors, giving a full 360-degree view. This also comes in the wake of vandalism against its cars in LA and San Fran. Their stance is doubly important when you consider the automobile exception to the Fourth Amendment, where the standard for searches is lowered from probable cause to reasonable suspicion. More companies need to follow suit and start putting their foot down to law enforcement. Maybe Waymo can start the trend. If nothing else, they could demonstrate that this position is good for business. So enjoy your shiny new silver Cluon, Waymo, and don't worry about picking it up. It'll deliver itself to you. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to Bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-age children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at Bogosity.tv/TuttleTwins. And now let's confustationalizmentify this week's Idiot Extraordinaire. Oh my God, what is it going to take? Either for Microsoft to shape up finally, or for everyone else to realize that Microsoft's products are insecure pieces of crap and you should never, ever use them for any critical applications. Ascension, a Catholic nonprofit, is one of the largest healthcare networks in the country. Some 140 hospitals, 50 clients, and 40 senior living facilities. They suffered a massive disruption of all their clinical operations, which culminated in a ransomware attack. The attack took down VDI and VPN connections that are crucial to communication between hospitals and clinics. It disrupted surgeries and other procedures and led to the theft of personal and medical data of some 5.6 million patients. The attack used a vulnerability called Kerberoasting, which is only possible because password hashes are stored using the vulnerable RC4 algorithm. Since Kerberos gives up the hash instead of keeping it server-side, attackers can get the hash just by making a login request from the Kerberos key distribution center. They can then crack it at their own leisure on their own machines. RC4 is an old algorithm from the 70s that's been broken for some 20 years, but attacks became commonly feasible by 2013. At that point, the use of RC4 was deprecated in TLS and other secure protocols. Microsoft announced that they would disable the RC4 cipher suites in their OSs and browsers by September 1, 2015. So why the hell are they still using it by default in Kerberos? Giving away the hash isn't good, but if they'd at least upgraded to AES, it wouldn't have been an issue. Kerberos supports AES, but nothing has been done to move users over to it and disable RC4. All of this is to let you know not only how boneheadedly stupid this was, but how severe the implications were. How would you like this if it happened in the surgery you were having? Yeah, sorry about that. All of our systems went down in the middle of your colonoscopy. Just sit tight there. So hopefully, now you understand why Senator Ron Wyden is in a very justifiably bad mood. He sent a letter to FTC Chair Andrew Ferguson saying that Microsoft isn't just reckless, they're a danger to national security. Quote, I write to request that the FTC investigate and hold Microsoft responsible for its gross cybersecurity negligence, resulting in ransomware attacks against crucial infrastructure, including U.S. healthcare organizations, which have caused enormous harm to healthcare providers, put patient care at risk, and continues to threaten U.S. national security. Microsoft makes Windows, the most widely used operating system for personal computers. In addition, Microsoft has a de facto monopoly over the operating systems used by most companies and government agencies. Microsoft chooses the default settings, including the security features that are enabled automatically and the required security settings. While organizations can change these settings, in practice, most do not. Yes, that's the old tyranny of the default. At least make the default settings secure. In its default configuration, Microsoft Windows is incredibly vulnerable to ransomware infections because of dangerous software engineering decisions by Microsoft, which the company has largely hidden from its corporate and government customers. A single individual at a hospital or other organization clicking on the wrong link can quickly result in an organization-wide ransomware infection. Microsoft has utterly failed to stop or even slow down the scourge of ransomware enabled by its dangerous software. Geez, don't hold back. Tell us what you really think. He pointed out that the ransomware attack began because a single contractor conducted a search on Microsoft's Bing using Microsoft's Edge browser. He clicked on a link in Bing's search results, which was a link to malware, which was then on his computer. The malware quickly leveled up to an administrator on the Active Directory server, Microsoft's system for administering user accounts. Quote, Microsoft's continued support for the ancient, insecure RC4 encryption technology needlessly exposes its customers to ransomware and other cyber threats by enabling hackers that have gained access to any computer on a corporate network to crack the passwords of privileged accounts used by administrators. According to Microsoft, this threat can be mitigated by setting long passwords that are at least 14 characters long, but Microsoft's software does not require such a password length for privileged accounts. Yeah, sure, our car is secure, just lock the door. By the way, they don't come with locks. Microsoft, over 10 years too late, said they were going to give organizations a security update which will allow them to disable RC4 and use more modern encryption technologies. 11 months later, they still haven't released that update. This isn't just about the Kerber roasting attack. This is about a culture of safety, or lack thereof. This is how they treat all of their crucial products, and it's nothing short of outright negligence. To make matters worse, quote, there is one company benefiting from this status quo, Microsoft itself. Instead of delivering secure software to its customers, Microsoft has built a multi-billion-dollar secondary business selling cybersecurity add-on services to those organizations that can afford it. At this point, Microsoft has become like an arsonist selling firefighting services to their victims. And yet, government agencies, companies, and nonprofits like Ascension have no choice but to continue to use the company's software even after they are hacked, because of Microsoft's near monopoly over enterprise IT. Yeah, I miss Novell. NetWare was great. He didn't recommend a specific course of action, but he did say, quote, without timely action, Microsoft's culture of negligent cybersecurity, combined with its de facto monopolization of the enterprise operating system market, poses a serious national security threat and makes additional hacks inevitable. I guess the only thing we need to see now is this something that's finally going to make a difference, or just more shaming of a tech giant so that Wyden can grandstand in front of his constituents? So all of that makes Microsoft this week's Idiot Extraordinaire. Well, that wraps up this put you on the rack, crack your every bone, scald you with hot oil, and remove the nails off your fingers with flaming hot pincers edition of the Bogosity podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support, and discord.bogosity.tv to join the discussion. Subscribe at the Discord, Patreon, or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Whitfield Diffie. The decisions we make about communication security today will determine the kind of society we live in tomorrow. The Bogosity podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.